As Representative Hightower comes back, we should be able to vote on things. So I'm going to call House Bill 230 with Minority Whip Representative Hughley.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I bring for your consideration House Bill 230. This is a bill that is a result of a study committee that we had during the interim, and it is designed to provide us with a process for compensating those who've been wrongfully convicted in our state. I want to thank your subcommittee for working with us and thank the Prosecuting Attorneys Council for their input. And we've been working with them, and I think we have worked out the concerns that they had previously. So I'll just run through the bill quickly. Basically, the bill just sets out a process. Of course, you know, we have the Claims Advisory Board, and the bill gives the Claims Advisory Board still the responsibility of investigating the claims of those persons who have been wrongfully incarcerated. It gives them the authority to have a special master to come in and help them as they review these claims. There is a section that tells what has to happen in order for a person to be eligible, and this is the section that we have worked on with the Prosecuting Attorneys Council, and there are several changes that I'd like to bring to your attention. That's section 28-5-112, starting on line 64. In order to be eligible for compensation, a person has to establish beyond a reasonable doubt, and previously we had clear and convincing evidence. And there are 4 things that they have to determine. First, that they were convicted of 1 or more crimes and sentenced to a term of imprisonment, that they have served all or part of the sentence, and number 3, we removed the language as it related to offered pleas so that the person has proclaimed his or her innocence. And then the 4th thing is that the person has to show that the wrongful conviction has been shown by verifiable evidence. And that's a change in that section that we did. The claim has to go before the board, and the person has 3 years in order to establish that they have a claim. And down on lines 80, about in the section starting section C on line 84, there's another change. There's new language here that says that we will provide notice to all of the interested parties, the claimant and the DA and any other person so involved in the case, so when the Claims Advisory Board meets, that they can hear all of the evidence from everybody associated with it. Basically, we set out that based on what the national standard is, $50,000 per year for each year of wrongful incarceration. That's the standard that we're using here. And then section 28-5-114 sets out how we would do that. So they would get $50,000 per year for wrongful incarceration, and if a person has been in prison for 4 years or more, it'll be an additional $50,000, and then there could be an annuity beyond that, and if it's for less than that, it will be a lump sum. And then there is new language on line 121, and basically the Prosecuting Attorneys Council wanted us to make sure that we only pay for the time that the person was actually incarcerated. So there's new language there that says that they shall include the time that the person actually spent awaiting trial, but not if they were released on bond. So basically we're saying that the person has to actually be in custody for the time that we're actually going to include in terms of determining how much or how long that the person has been wrongfully incarcerated. And there is one additional change where we have, it has to do with attorney's fees, and there was some language deleted such that any monetary limitation of damages awarded will be identified. And so basically, that's pretty much it. The Claims Advisory Board would meet and make a determination as to how long the person was incarcerated. If there is a valid claim, they would set out for the legislature how much that claim should be. A resolution would still have to be introduced, and it would go through our regular legislative process in order for a claim to be paid. So with that, Mr. Chairman, I'll yield, and if there are any questions, I'll be more than happy to try and answer.
Questions for the author? Representative Hightower.
Yes, ma'am. One of the things that concerns me about this bill that I don't see is I understand that this compensation would be coming from the state for someone being wrongly convicted, but if you look on line 63 through 71, I don't see anything there that says that they have to prove that the state acted in any bad way. In other words, essentially everyone did what they were supposed to do. They found no fault with the defense attorney. They found no fault, whether that be a public defender or not, and they haven't found any fault with the state or the prosecutor did anything wrong. It's just based on the evidence they had. Our justice system worked for that person at that time, but then they were able to come back later and prove they were wrongly convicted, but not for any wrongdoing on the state's part. But even if we don't find wrongdoing on the state's still paying a penalty. And I don't really know if you see what I'm saying? If there was like a number 5 there that said they had to prove there was some type of wrongdoing on behalf of the state, then I could see the state being responsible for that. But there's nothing here that I'm seeing that says they did anything wrong at any point in time, but yet the state's going to be on the hook for something. Does that make sense?
I understand what you're saying, but let's think of it from the standpoint of the citizen. The citizen essentially has to prove that they were innocent of the crime for which they were charged and they served time in prison. It does not necessarily say that the DA or the judge or anybody acted in bad faith. Essentially, they acted based on the information that they had, and the information that they had was not correct. In any event, the citizen would have given up years of his or her life for a crime that they did not commit. So I think that's the standard that we have to get to, whether or not a person was convicted and served time for a crime that he did not commit. We're not trying to say that the state has done something wrong, and so that we're compensating because the state did something wrong. We're compensating the person because on behalf of the citizens of the state of Georgia, we took away a person's liberty for a specified time, and those are years that person cannot get back. And so that's what this compensation is about, and that's what it's about now, and that's what it always has been about.
I'm just having trouble wrestling with the state being on the hook when the state didn't do anything, and we don't have any standard for the state to be held against. And I understand your point. I really do. I understand the person was wrongly convicted. I understand they've lost time in their life, but I don't know. I don't know if I can wrap around the concept of holding the state liable for those type fees or penalties, so to speak, when we have no standard to show the state acted in any bad way. But I'm still.
Well, think of it this way: do you want to create a standard that an individual cannot meet? Because you're talking about an individual, and from your way of thinking, the individual would have to show not only that they were innocent, but the state did something in error to cause them to be convicted.
Sure. An example would be if you have, and it happens. I mean, it happens at times. You have a defense attorney or a prosecutor that's found to have acted in error. In other words, you have a defense attorney who's been found to have committed malpractice because they didn't do something correctly, and that contributed to the sentencing. Or you had a prosecutor that was found to act outside their prosecutorial discretion that advanced something in the case. In other words, they withheld evidence illegally, or they didn't provide evidence. If those were things, I think if that had happened and it's a state employee, something that the state was at fault for, I mean, I'm not saying I could get there, but it'd be a little easier for me to get there. Right now, we're just saying, man, we know this is very unfortunate, but we're gonna pay for it. I don't know. But I do see your passion and compassion for those people.
Well, as I said, you know, you were talking about an individual against the state of Georgia, and we have not had a lot of these cases. We've had about 6 cases in the last 15 or so years, and the problem we have now is that the persons get out. We bring forth a resolution to pay them. The state has been paying these claims, but as we currently sit now, there is no standard. Whoever brings the claim, it depends on who sits in our seats,
Sure.
The legislature whose district that they reside in, and their politics, and that the system that we currently have is inherently unfair. If you look at the awards that we've paid, some people have been paid $25,000 a year, some have been paid $55,000 a year for every year of incarceration. Basically, we're just trying to set the standard of what that will be. We're not changing our process of doing it. It would still go before the Claims Advisory Board. It would still go through appropriations. The 180 members of the House and the 56 members of the Senate, whoever is seated at that time, would still have to give the final authority that these awards would be paid. So there are so many hurdles between a person saying that I was wrongfully convicted and the state paying out money, that we have safeguards in place all along the way. And as a person who has brought 2 of these, I can tell you, it is not easy. It is not easy, and there are safeguards along the way, and no legislator wants to put forth a claim if they are not convinced themselves, and they've not talked to their local DA and the judges and everybody at home telling them that this is the right thing to do. And that's exactly what I did. If the DA had said no, or if the judge had said no, but in the cases I brought, they said yes, this person was wrongfully convicted, but we would not have had the evidence that you suggest to show that there was some malfeasance on a part of anybody involved in our justice system.
Representative Randall.
Thank you, Chair. I think the point here is that precedent has been set in these cases, and the legislature has passed 6 and 15 years, so that's already set. Precedent has been set. But what she's trying to do is.
Representative Randall, you might want to. I think the microphone's off on the back button. Yeah.
What she's trying to do is just put some uniformity to it. I mean, and a lot of it is based on the politics of the person and how big that case was in the state, and you know who else got involved, and people that are sitting in our seats. So precedence has been set, and they've all passed. So since they are passing, and rightfully so in my opinion, in this case that may not matter, but precedence has been set. We've been paying this out in this way, but at different levels, at different pay structures, and all she's trying to do is put some uniformity to it and put some steps in place where someone will be reviewing it and pretty much just putting it in line. I mean, I don't know. I think that's a good idea because they're not going to stop coming. There are going to be some cases like this, and then we're going to have to take a look at them as a legislature and make a decision. And if they go the way they've been passing the legislature, but at least this will put something in place to where we know that when one comes up, this is how it's going to be handled, every one from now on after this legislation passes.
Representative Gravely.
Thank you. I just had a question, really. How many cases like this have we had in Georgia?
We've had about 6 in the last 15 years.
And was there fault found in those cases, or was it just defense or be it the plaintiff defense? Everything went off okay in trial. There wasn't any mistrial. There wasn't any withholding of evidence.
The typical case is a case where a person's conviction was overturned because of DNA evidence. And so at the time the case was handled, everybody was operating in good faith. They were operating on the basis of eyewitness testimony, which you attorneys know can sometimes be faulty. And people spent, in some cases, 20 years in prison before the DNA evidence came about that proved that the person was innocent of the crime for which they were convicted. So, I mean, you know, there was no fault on the DA, no fault of the judge. They were operating based on the evidence that they had at the time.
Mr. Chairman. So in the last 15 years, we've had 6 that were found to be innocent.
Mm-hmm.
Okay. Thank you.
Chairman Setzler.
Hey, Mr. Chairman, Representative Hughley. We've had some discussions over the years on this issue. I want to ask you. I have supported one of these, and I've opposed every other one. In fact, I've gone to the well against these before, because my concern in the past has been that there are people who are imprisoned and later exonerated for offenses that are of lower order, perhaps in some of these, that really get nothing. Last one I supported, and I told you why, and I think it was a strong one. There was a case of ineffective assistance of counsel.
Right.
The government appointed defense attorney in a indigent case did not do his or her job, and that was really the basis of the person being convicted. And I think the state does have an obligation to provide an adequate defense attorney. And in those circumstances, I think there is in the back and forth. What does the state have a duty to do? What does the state have a financial duty to remedy? And I say this as somebody who it's. I mean, the prosecution's got a lot of resources, and we all of us ought to look with some level of there, but by the grace of God go many of us, and I'm certainly aware of that. But my concern is, as you systematize this and put something in place that begins to take the form of a legal right, and I've got my dear friend from Macon here saying we've set a precedent, we've got this momentum behind this issue now that we then have a duty to follow through on. This idea of this emerging duty of the state to make these things right financially in these big cases. You've got smaller cases where people are wrongly in prison. They lose their job for being in jail for 72 hours, and they're found to be perhaps the facts leading to the arrest were invalid. There's no claim they can make back on the state. Are we putting in this, and if so, where in the bill is it, where we speak to ineffective assistance of counsel as an element of this, where the state had a duty to do something that it did not fulfill, where we can see that there's some meaningful responsibility of the state that it did not follow through? Is that in any part of the bill?
No.
I just share that as a concern for committee members. I'm not a self-professed expert on this. I wrestle with this. You've got people who've lost years of their lives. I'm not insensitive to that. I just struggle with what, as we codify this, how do we wrestle through this?
Well, let me just remind each of you that anybody can bring a claim against the state of Georgia, and we have a claims advisory board to look at those claims. The smaller claims are handled by the board. Larger claims are brought before the legislature by means of a resolution. And if we don't do anything, we keep what we have. And if someone brings a claim against the state, they go to their legislator to ask them to bring forth a resolution. God forbid nobody asks you to do that, and the evidence shows that the person has been wrongfully incarcerated, because it is up to you to determine in your resolution what we should pay that person. You have to make the original ask. And then you have to go and talk to the appropriations chair and convince the appropriations chair, let's come up with a standard for how we're going to pay this person. One person we paid based on the fact that the person was all set to go to the military before the conviction. The other person we paid because I picked out a number that I thought was good, and the legislature said okay. That's not the way we should do this. And that is the reason why I feel it's important for us to set some type of standard, something to go by. Because as it stands right now, you can ask for whatever you want. and whatever you can get the body to agree upon. And that is not an appropriate way, in my mind, for us to do it. It's not fair to the individual legislator. It's not fair to the Appropriations Committee. And it's not fair to the 179 other members that you're asking to vote on these type of resolutions.
The chair will comment that I sat on the study committee during the summer, and I think apart from the section from line 63 to 71, which I think there's some different view on that, in terms of the amount was kind of uniform. We looked at other states, and it was kind of uniform. In addition to some of the benefits that they could qualify for to get them back to being a productive citizen, and so the uniformity, I think, is a very, very important part of kind of how do we, once they qualify, how do we treat them equally to the other individuals who are in a similar boat. Chairman Atwood, then I'll recognize the minority leader right after that.
Yes, I thank the gentlelady for bringing this. I've wrestled with these also. I voted for one and voted against one, and part of the problem was the standard. And I thought long and hard about it. I really have. After going through this year as Public Safety Subcommittee Appropriations Chairman, I've thought about your bill. And I think, and to answer Representative Hightower, or comment on Representative Hightower's statement, even though someone, in my opinion, this is only my opinion, but even though a prosecutor or someone else maybe did not do something technically wrong, or we couldn't find it, the person was still incarcerated. Their privileges were still taken away, and we have a duty in the legislature of being sure we properly fund agencies, that we properly fund public defenders and prosecutors and judges, and we hold them to a high standard. And if a person is locked up in a state penitentiary, we're not talking about a jail, we're talking about a local county jail, a state penitentiary, it would seem to me that somewhere in the system something has failed. And what does that person then do with their rest of their life? And do we have a duty? And I'm not sure I'm there yet. I've got to think some more about it, but I just want to throw it out for the committee to think. Do we then have a duty, even though we can't show, we do know for a fact that person was locked up, their rights and freedoms were taken away, and they could not pursue and be with their family? Do we have a duty as a state to then compensate them? And I'm starting to side on the side that yes, that we do, that we have, as long as we have standards in place. And I know that Representative Coomer's got a couple of good comments here I think he wants to talk to you about. That's just my thoughts, Mr. Chair.
Madam Minority Leader.
Thank you, Mr. Chairman. Madam Whip, is it not true that in addition to, I think, the very thoughtful comments made by Representative Atwood, that this would create a standard that would also unify the House and the Senate? Because one of the challenges that we face is that as the author of a resolution, you not only face the issue of convincing 179 members of the House, but in at least one case that I know of, one of these resolutions became a political football, and we changed the standards that were imposed by the Senate. And what this would serve to do is not necessarily create a duty for any compensation to be granted, but to set a level playing field for any member who is called upon to bring this resolution forward, because our rules require that each individual legislator be responsible for bringing this forward. And depending on your stature or status in the House or the Senate, the very real risk is that the person who has been incarcerated wrongfully could be disadvantaged simply because of the status or a disagreement between the House and the Senate, as opposed to anything that goes to the merits of their underlying case.
That is exactly correct. And I would have to say that my constituent was disadvantaged by the fact that his legislator is not an attorney. And this is strictly a legal matter, and all of you guys are way ahead of the game as it compares to me. So it would have been definitely helpful if there were some guidelines and some standards for us to operate under. Let me also remind the committee that 30 other states and the federal government have outlined a process for this, and that's the basis for what we're recommending here today. So I think In terms of how we determine a person is eligible, that might be up for conversation, but the fact that there needs to be a uniform process for how we handle these cases is something that I believe that we have a responsibility to do.
Governor's floor leader.
It's just Representative Coomer right now. Just asking questions for myself. The first one really is to council. Do we have a private cause of action for wrongful or malicious convictions and prosecutions in the state now?
Under Article 4 of Chapter 5 of Title 28, if you could meet the criteria there, you could bring the claim. I don't think there's anything specific as to that cause of action, and I haven't read that article. It's 28.560 through 86 recently enough to know whether or not something like that would qualify. I don't recall ever hearing of anything like that.
It's my understanding throughout the committee process, we had an attorney from DOAS come speak. My understanding that the state has not waived their immunity with respect to this, so this would be kind of like a workers' comp. If you could prove it, then you, in lieu of your right to sue, you get awarded. I believe that's what the testimony was, Representative Coomer.
I think I saw something in one of the latter sections of the bill that talks about if a person receives compensation under this part, they would be waiving other claims.
Right.
But not necessarily if they filed a claim under this part. You file a claim and lose, and then you'd still go file your lawsuit, I guess. That's just, I think that's what I read. Well, let me move on. My next question, I made the Superior Court judges mad earlier at me this year, so now I'm going to take on the rest of the bar. Looking at lines 118 and 19.
Could I move just a moment?
I see that we are including a provision for reasonable attorney's fees and other expenses incurred by the claimant in connection with all associated criminal proceedings and appeals, and if applicable in connection with obtaining the claimant's discharge from confinement. So that's not necessarily, in fact, it's not at all the attorney's fees for bringing the claim seeking relief. It's attorney's fees for all of the previous actions the person undertook in defending their original case. Is that correct? Is that the way I understand that correctly?
Yes.
Okay. My question is, do you think that having something that pays attorneys to bring these claims will result in more claims being brought than we've seen in the past? Do you think we'll make ourselves a more attractive target by incentivizing attorneys to bring these claims for people?
I really don't think so. There was a case where there was an attorney, and those persons, in my experience, those persons who have paid attorneys fared a lot worse than those who did not, because the General Assembly balked at the fact that the person was represented by counsel. And so it has not proven to be an advantage based on our prior history.
Well, my question is going forward, providing that we're going to offer some award of attorney's fees, is that going to create an incentive for more people to get an attorney to bring the petition to the board?
I really don't think so, because we still got to go back to the fact that the person would have been wrongfully convicted. So either you are, or you have, or you haven't been wrongfully convicted. And keep in mind that these cases are few and far between. So I'm not a learned attorney like the rest of you guys here, but I don't see that a person is going to be convinced that they're going to do that. If you're wrongfully convicted, you're going to do everything you can to get your case overturned and get back in front of a judge in order to secure your release. That's what you would do. That's what I would do. And so whether the attorney's fees is in here or not, it's not going to, in my mind, factor into that.
Okay. Just a couple more questions, if I may, Mr. Chairman. They go back to the lines in 28-5-112 related to really lines 66 through 69, a couple of different issues. Let me start on line 69. One of the requirements is that the claimant proclaims his or her innocence. And I had a question about whether a guilty plea in a case would, in fact, eliminate a claim under this section. I know in a previous version of the bill, there was a provision that specifically said a guilty plea would not eliminate a claim, that if a person took a plea under North Carolina versus Alford, that they could make this claim in spite of that sworn plea. Is there a position that you're taking with regard to the plea of guilty, and I guess frankly, would you be open to some language that would say that a plea of guilty would eliminate the ability to claim under this section?
Basically, the committee, when we were looking at it in the interim, realized the fact that in criminal cases, sometimes people are advised by their counsel to plead guilty because of the circumstances when they may not be indeed guilty. But when you're looking at a 10-year sentence as opposed to a 20-year sentence, that might be in your best interest to do that. So that was the thinking of the committee and the reason why that was in there originally. And after working with the Prosecuting Attorneys Council, we have taken that out and gone back to the stance that the person proclaims his or her innocence and that the wrongful conviction has been established by verifiable evidence. So, you will have cases like that to come forward where, the person has to look at where they are and make the best judgment.
And I suppose then that, to further that line of thought, if a person makes a claim and they have this hearing before a special master, we would expect that special master to look at the disposition of the case, and if they pled guilty, then the special master could just consider that for what it's worth at the time, I suppose.
Yes.
Okay.
Yes.
And then the last two questions both relate to lines 66 and 67, subsection 1. Well, I guess they also relate to section 2 to some extent. It says if the claimant was convicted of one or more crimes and was sentenced to a term of imprisonment, and then again, claimant has served all or part of the sentence of imprisonment. I'm a little concerned about, well, let me ask you, when you say term of imprisonment and sentence of imprisonment, do you intend that means the person has actually spent some time incarcerated?
Yes.
Okay. The reason I ask is because, and the other folks may have a different read of it than I do, but every time I go to court and I am standing next to somebody who's entering a guilty plea, the judge says, if they're getting a probated sentence, the judge tells them your probated sentence is based on a term of incarceration, or term of imprisonment, and you're allowed to serve that term while you're out free on probation. What I'd be worried about is if we don't make it a little more clear that we're talking about actual incarceration, that this could be taken to mean that if you were sentenced to a term of imprisonment, even though you never served a day in jail, if you can prove you were not actually guilty at some other time and you're within 3 years of finishing your sentence, then you would still be able to get this benefit.
Well, that's why we say in number 2 that the person has served all or part of the sentence of imprisonment. So they actually would have to have been not just in jail sitting around waiting for trial. They would have to have been in prison in our Department of Corrections is what we're talking about. But it's up to the wisdom of the committee if it needs to be clarified.
If I may, Mr. Chairman, could maybe somebody else will speak to it later. Maybe we could hear from PAC or somebody on that specific point. Okay.
If you look at line 121 and 122, there's some clarification.
Okay. Thank you.
Representative Strickland.
Thank you, Mr. Chairman. Representative Hughley, help me on one part. Right now, you brought resolutions in the past, I know, for compensation for wrongful convictions. Right now, who makes the determination as whether or not that person was actually innocent? How does it work right now?
Right now, what has to happen is the person, before October 15th of any year, they have to submit a claim to the Claims Advisory Board. And the Claims Advisory Board meets and they look at the evidence and they make a recommendation. Now, as legislators, we can take that recommendation or we can not take that recommendation. But we have a responsibility to file the claim before the 10th day of the legislative session, and it goes through, as a resolution, it goes through our process. So we have to convince the Appropriations Committee and everybody that the person is indeed innocent. And in order to do that, I had to look at all of their case information, and because of the fact that I'm not an attorney, I went to the DA, I went to the judge, I went to everybody involved in the case for them to tell me if there was something going on that I did not see, or was there something else that we need to consider. And after they signed off on the fact that the evidence that as I was reading it was correct and the person was wrongfully incarcerated, that's when I went forward with the case. Now, everybody might not do that.
Right.
But that's what I did because I wanted to be sure before I asked my colleagues to vote on something to compensate somebody that there was no doubt that the person had in fact been wrongfully incarcerated. Right now, there's no obligation to do that.
Well, I was going to ask you right now. I mean, I struggle with these a little bit too. I can see both sides of this. But right now, as we understand, there's no standard set up like this where you have the burden on the claimant beyond a reasonable doubt to prove their innocence. And it sounds to me like in the past, there's a lot of politics could go into this. At least with this bill, we now have a procedure that can be put in place where the burden is on a claimant to prove that beyond a reasonable doubt, the tables turn, reasonable doubt, they are actually innocent. And it's just in my mind, I think that would make it a lot cleaner process, a lot more open process. And that way, we're not trying to decide on the floor of the House without ever even seeing the file or knowing what went on, whether or not this person actually deserves compensation. And one thing I noticed in the bill, too, is it's my understanding that the district attorney for the circuit in which the conviction occurred, in line 87, would actually get notice of the hearing as well. Is that right? Where they'd have a chance to go in and present evidence to prove the person actually was guilty, if they had an interest in it.
Right.
All right. Thank you.
You have a couple more questions, but I think a lot of discussions around the section line 6371, and I know the speakers probably have people have signed up, probably have some comments to that. Hopefully that will at least answer or cover some of the questions that are lining up here. So since everybody had a chance to ask a question at this time, I'm going to recognize the speakers, then let the committee members ask further questions later. Sandra Michaels.
Thank you very much. Sandra Michaels for Georgia Association of Criminal Defense Lawyers and the Georgia Innocence Project. We thank very much Representative Hughley for doing this. We also attended during the summer hearings, and there was a tremendous amount of work that went into this bill. We support it wholeheartedly. My only one concern I have is that 30 states in the United States have compensation statutes. All of them have less than beyond a reasonable doubt that the claimant must prove whatever the standards are. Our only concern is in lines 64 and 65, the beyond a reasonable doubt. That was changed from a preponderance of the evidence from when the bill was first drafted. And I think, as correctly stated, a lot of politics go into the request. As someone who's represented someone that was wrongfully convicted, mistakes happen. What it is, this is a person that's actually innocent. For whatever reason, DNA, evidence, and I would note that all 8 wrongful convictions in the state of Georgia were a basis of wrongful identifications. So, again, we support this bill. We support the concept of having a structure in place so there's not a big debate every time. I'm just concerned that the beyond the reasonable doubt section has been changed when 30 other states have a lesser standard. That's a huge burden, and that's a criminal defense burden And almost all civil actions have a preponderance of the evidence. But again, we support the concept of the bill. That's just our only concern.
Any questions for Ms. Michaels?
Thank you.
Thank you. Oh, one question, Ms. Michael. What is the majority of the states?
Preponderance.
Is it
I have a
preponderance?
chart. It's a long chart, so I didn't make everyone copies, but it's.
Is there
yeah,
some? What about the other states?
There's
Is
a
it clear
few
and
that have
convincing?
clear. Do you want me to list the states quickly?
No, I just.
Oh, clear and
just wanna-
convincing is one, but almost all of them are preponderance of the evidence. Preponderance of the evidence and clear and convincing are the two.
Okay. Thank you.
And I can provide this for anyone that would like it. It's a list of all the states that have it. 30.
Okay. Chuck Spade-Haas and Todd Ashley.
Thank you, Mr. Chairman. If I could just briefly, Mr. Chairman, we want to thank the author for working with us. We do believe that she's brought forth you a much better written bill. We've listened to some of the same issues that some of the committee members have struggled with. We've put this together in part and whole on some of those comments. So we appreciate her taking our input. We do believe that streamlining and creating a process that's codified, that creates a standard, all of those things are good. That also keeps a lot of those types of issues surrounding these cases out of the purview of the legislature trying to make a decision, quite frankly, in the committee or on the floor. So we commend her for that. As to the standard that's been discussed in 64 to 71, we believe that's a good compromise to deal with some of the concepts, keeping in mind that it doesn't require a bad act on behalf of the state. So it balances all of that. As far as the in-custody thing, I agree with Legislative Counsel that it's addressed at 121 and 122. That being said, if we're going to clarify it, maybe it just needs to be at 121 or 122 in calculating the time in prison. The board shall take time in custody, which is, I think, the language you were looking for, maybe before and after trial, just to clarify that you're calculating days in trial. So as it stands, the prosecutors of the state have not taken a formal position on it, but we believe this is a fair attempt to deal with this very delicate issue, and that we will go back and say that accordingly. So I'll take any questions.
Chairman Sessler.
Thank you, Mr. Chairman. I'll go through a couple. I don't know that these are in any particular order. I've got a concern on the, when you're in a defense circumstance in an initial trial, you put up an aggressive defense. Should there be some duty to provide, if they make a claim or make a statement, for that to be sworn, so they can't just put up some wild claim as an effort to try to get there and take a swing at trying to win this thing, or should they be able to put up anything they want to and really be able to do that with impunity? A claimant.
Well, I think you raise a couple of issues that aren't specifically addressed by this, but there are recourses available. I mean, this is an establishment of government. I mean, this advisory board. So submitting false information or false documents to this would potentially be a crime under 161020. So where you could put some sort of additional preventative measure in here, I would caution you that you've got a pretty broad statute now that prohibits making false statements or false writings to the government, and this would be a state government. So,
but I mean, as in a defense setting, though, it's a little different in their circumstances. I mean, if a person, I don't know, trying to unpack that and whether we're creating an incentive for someone to take a wild swing at this, but
I think what this does, though, is quite frankly, it delegates to this board to sort through those cases. In other words, you would rather this board be sorting through what may be an invalid claim than you would this body. So I think that's part of one way of looking at it.
Mr. Chairman, another question I've got, if I could, Mr. Chairman, is on line 173. This may be more of a question for the local governments. 171 through 173. Any claimant who receives compensation shall not bring any action involving the same matter. Obviously, they're basically giving a waiver for future claim against the state. do we need to, this, I guess it's a technical question, would we need to say state or political subdivision? I mean, if the arresting agency, for example, was a local law enforcement agency or sheriff's department, and as you unpack the case, you find out that there's a wrongful conviction that's ascertained. The state pays out on this. It would seem to me that if you still have a right of action against the local government, you could say, well, hey, the state paid me X dollars for this. They declared beyond a reasonable doubt that this was a wrongful conviction. Now I've got a right of action against local governments. Do we need to not ensure that this is kind of the final payout, as it were, to protect local governments and local law enforcement agencies as well? Does this bill open that door, and perhaps unintentionally?
I would say that this bill doesn't prevent what you're talking about at this point. That's a policy issue if you're going to modify that.
One further question, Mr. Chairman?
Sure.
Representative Coomer did raise it on 118 through 119. And I need to get clarity on this as well. Talking about attorney's fees, if someone incurred $25,000 in attorney's fees in defending their case the first time, they go to prison, spend X time, and they come back and spend $10,000 making this claim. Does this give them access to the $10,000 in attorney's fees and cost of the claim? Does it give them access to the full $35,000 that would be within the associated criminal proceedings and appeals? Would it give access to the full? And was that the intention?
I can't speak to the intention, but it clearly would give access to any and all dollars spent in associated criminal proceedings, appeals, and otherwise connected. The policy of that is, I mean, if you're not getting to this until you've gone through this standard and all this has been established. So, but clearly this would allow for any and all.
Mr. Chairman, I guess one last question. Who would the determination of beyond a reasonable doubt rest with in this case?
Well, for purposes of this process, this board. In other words, as the author said, at the end of the day, this is about a process where this advisory board is going to make a recommendation to this body. So this is the standard by which they would have to find the claim before they come to you with recommendations.
Representative Coomer.
Thank you, Mr. Chairman. Mr. Spass, in looking at the section that begins on line 94, the bill provides that in making its recommendation to the General Assembly, the board shall, and then in part 2 on line 97, if the claimant was in prison 4 years or less, include $50,000 per year for each year of imprisonment. And that $50,000 per year amount is also mentioned in line 99. Did your organization have any input in determining what that amount of money should be?
We obviously had conversations with the sponsor and the people working with the sponsor. We do believe that that's the standard that the federal government has used for this type of concept. And my limited access to some of the other state statutes, I think this is fairly consistent with what's become the norm for that.
Okay. And the other thing that's kind of an interesting interesting way of wording this is a recommendation to the General Assembly for an amount of payment, but then the bill actually tells the board what its recommendation should be back to the General Assembly based on the number of years of incarceration. Is that what sort of mirror the federal practice as well?
What you've done is you've established a basis for their recommendation, because one of the part of this whole process is if this General Assembly is going to be recommended for one of these claims that's gone through this process, as Chairman Atwood talked about managing the budget, somebody's got to have a number to put in the budget in a particular year when this is done. So this is kind of backdoor codifying a policy that this is what you're going to settle on as the policy for compensation. It doesn't tie the legislature's hands to that, but it's certainly set public policy, and it's told the board what formula to use to make that recommendation.
Thank you, Mr. Smehouse. Mr. Ashley? All right. I'm going to give the author a final time up here if you want to use it, and if there's any further questions on the bill by the members of the committee.
I know you all have other business. I just want to say one final thing, and basically is this. Whether we do anything with this bill or not, if somebody has been wrongfully convicted in the state of Georgia, they can bring an action to this General Assembly. All they need is one legislator to put forth their resolution. The claim is a one-page form that a person fills out and sends to the Claims Advisory Board in the required time. And there is no recommendation in terms of how much money can be asked for. The person just says, I think I am due $2 million, and send it in. And we are left in a situation where we have to come up with a number. We have to decide, what 1 year of a person's life incarcerated is worth. And none of us can do that and do that fairly. What we're trying to do is set out a standard here. What we really wanted to do in our committee was to take it out of the political process, so that when we have these cases, everybody can be treated the same. But our Constitution won't allow us to do that. It has to be a resolution. It has to come before this body. So any concerns that we have, this legislature will have the final say. And it cannot move forward, regardless of what the recommendation of the Claims Advisory Board is. It cannot move forward unless it goes through our normal process. So I believe the safeguards are in place. It gives us a track to run on. And I can assure you that it is not easy to convince 91 people that a person has been wrongfully incarcerated and get a bill through, and then go to the Senate and convince the majority of their members too as well. The thing that really concerned me more than anything else, on the two resolutions that I've done, on one of them, at the last minute, the Senate put on the resolution a requirement that this person has to be drug tested, and they have to be employed at all times in order to receive the funds. But we don't have a mechanism in place to drug test the person. DOAS doesn't do that, but we put that in the bill. And so what are we to do? What are we to do with that? So that's why we need a standard and a process in place, so that we don't get caught up on day 40 at 11:59, and that's when these things pass, and just throw something out there. So that is my concern, and that is why that I think it is important for us to establish a process. Now, I appreciate the speaker and the study committee taking a look at this, and it is in the wisdom of this committee. If it's something that we need to carry over and look to next year, that's fine with me. But we have a responsibility to set a standard, and I hope that at some point, at some place, we will do that. Thank you.
You had a question.
Okay.
Representative Coomer.
Thank you. Just one last thing. Excuse me. As I was reading on line 157, 158, well, really starting 156, it says any award of compensation made shall not be subject to state income taxes, provided, however, that the award of attorney's fees shall be subject to taxation. And I don't have a problem with it being not subject to income tax. My question is, I'm just curious to know how you came to that conclusion that part of it should be subject to taxation.
The award, as it is done now, these awards are we normally put in the resolution that they're not subject to the income taxes. Now, the attorney's fees, I don't know. Maybe I can get Jill to help me with that one. In terms, I know right now the award itself is not subject to taxes. However, the federal government does not waive its money. They will get their taxes from these particular awards. But I'm not exactly sure. Can you help me with that on there?
From my memory, it's based on what they did in other states where they allowed attorneys fees. That's my memory from the study committee.
One last question from Minority Leader.
Actually, I wanted to make a motion at the appropriate time.
Correct. And that's the time. What's the pleasure of the committee?
Chairman, I'd like to move to pass LC 296553S HB 230.
Minority Leader moves LC 296553S, which is a substitute to HB 230. Anybody second? Okay. Any amendments? Okay. Okay. Representative Coomer.
Thank you, Mr. Pack, Mr. Chairman. First would be on line 122, striking the words awaiting trial and adding the words, well, actually, it wouldn't need to strike the words awaiting trial. It would just be adding after the word trial, comma, during trial, comma, and after conviction. And the purpose of that amendment, Mr. Chairman, would just to clarify that that the calculation of imprisonment would be only for time that a person was actually, actually incarcerated in custody, not just serving a term of imprisonment, because that could be served on probation.
Okay. Ms. Travis, did you get what the proposed amendment is? Okay. All right. Any discussion on that amendment?
My concern is that, and I appreciate what you're trying to do, Mr. Coomer. My concern is that we have had a number of issues where people have been incarcerated and held for prolonged periods of time. And so, especially if it's part of the behavior that leads to the wrongful conviction eventually being overturned. I certainly understand prior to trial, but I understand the intent, but I do think that since incarceration has to be a component of their receipt of this award, I would actually oppose including that language, because I think it removes responsibility on the part of the prosecution and on the part of, putting aside the prosecution, being a part of a county that has had a number of issues with meeting the speedy trial requirement. I think this is an unnecessary amendment.
If there's objection, would you move?
Yes, I move.
Okay. So move. Okay. Gentleman moves. All those in favor of the Coomer amendment to line 122 indicate by saying aye.
Aye.
Aye. Those opposed?
No.
Let's have a hand count there. Those in favor of the amendment, raise your hand. 5. And those opposed? 4. The ayes have it. The amendment passes. Representative Coomer, you have another amendment?
Yes, sir. I have amendment would be on lines 118 and 119 to strike the section that starts with the number 5, those two lines. I'm sorry, 118, 119, and 120.
It's amendment to remove lines 118 to 120. Okay. Any discussion on that amendment? Yes.
Again, I think it's important for us to remember that these reasonable attorney's fees are, number one, included in both the federal and other state statutes. But secondarily, you're talking about people who've proven their innocence and have been compelled to pay sometimes fairly substantial fees to prove that innocence. And if this is part of the continuation, the pattern that we're trying to address, I think it is highly reasonable to allow access to these attorney's fees. We're asking the board to consider what the reasonableness is, and I think if we're going to delegate that responsibility, we should give them the ability to recognize that attorney's fees are indeed an essential part of any wrongfully incarcerated person achieving their innocence.
Okay. Gentleman move?
Move.
Gentleman moves for his amendment, Coomer Amendment number 2, removing lines 118 to 120. Those in favor of the Coomer Amendment number 2 indicate by raising your hand. I'll raise. Okay. Those opposed? The Coomer Amendment number 2 fails. Do you have any other amendments?
One more.
Okay.
Excuse me. On line 157, striking 157, 158, striking the words, provided, however, that the award of attorney's fees shall be subject to taxation.
Okay. So from 157, you strike the semicolon? first?
Semicolon, yes.
Okay. And all cut all the way
Well,
through?
no, you wouldn't strike the semicolon.
Okay.
Well, there's a semicolon, then there's provided, and then it ends with a semicolon or, so.
Okay. So one semicolon.
And the point of that is to
Hold on.
just provide that if there is,
Representative Coomer, could you repeat the amendment?
yes,
You're proposing?
beginning on line 157 with the word provided, and striking out the words provided, however, that the award of attorney's fees shall be subject to taxation, semicolon.
All right. You get that, Ms. Travis?
We're striking and provide them.
Right, yes. Right, so that the entire award of compensation would not be subject to state income taxes, and there would be no distinction between the part for attorney's fees.
Discussion on Coomer Amendment number 3. No one's doing that.
With the attorney fees, the taxes on the attorney fees, wouldn't that be is that not there because that's considered income? And the overall settlement isn't considered income to the individual that's receiving the money. But the attorney fees would have been a cutout, which would have had income.
Okay, well, Minority Leader.
Yes, I mean, essentially, the attorney's fees are awarded to the attorney, so you'd be giving a tax benefit to the attorney for the purposes of acting in the process of their job.
Any further discussion on Coomer Amendment number 3?
Mr. Chairman?
Representative Coomer?
Yeah, looking back, the recommendation to the General Assembly is to include reasonable attorney's fees, but that it doesn't say that it's to be paid to the attorney. And my experience would be an award of attorney's fees is going to be paid to the party, and then whether the party pays us or attorneys up to the party, I think. And even if the attorney does get the award of fees, if I get an award of fees in my practice, $1,000, whatever, it's up to me to pay the taxes out of that. I think, I mean, it's the committee's pleasure, but I just think it makes it simpler, easier to manage.
No further discussions. All right. Those in favor of Coomer Amendment number 3, striking the word starting with provided in line 157, all the way to the semicolon in 158. Those in favor of the amendment, vote by raising your hand. Those opposed? Okay, amendment fails. All right. Any other amendments? Chairman Zessler.
Thank you, Mr. Chairman. I'd like to direct the committee's attention to lines 171 through 173, please. It's going to offer an amendment here, modifying on line 173 where it reads against the state. My policy objective is to, if there's if compensation is granted, there ought to be that ought to end the action with respect to further actions against the state, any political subdivision of the state, or any official. I don't think it's appropriate if there's a state payout in the way that we identify that a claim could be brought against a prosecutor, against a city, county, sheriff's agency. So I think I've tried to craft an amendment. Perhaps council could even help me do that. But my goal is to make sure that if a payout happens, there's not then a payday that could be gotten from a city through a lawsuit or from an official. I would offer, again, if this kind of waiver would apply to an official naturally, my amendment would simply read on line 173 against the state or any political subdivision of the state. Period. I would like to ask council if that would apply to officials vicariously as well.
I'm a little confused because this whole setup is only against the state. It's not against, like, I know Representative Gravely can help me more on immunity and tort claims against cities and counties and whether they exist. In Title 36 there is some specific language having to do with immunity for cities. The analogy here is the State Tort Claims Act is in the same part of the code. So I think this part is specifically designed to only deal with the state. Now, the district attorney would be an actor of the state, so immunity would attach there. But I can't speak for the county.
Representative Gravely.
Thank you. If we had a situation where you had a local sheriff, a police chief, or anybody at the local level, I'm not singling out anybody, who had, to no fault of the state, but had withheld stuff, and the state acted in good faith based upon all the evidence that they had, and the individual was convicted, it then is found out that it was a wrongful conviction, but the state was not at fault. In this committee, or be it some third-party investigation, determined at that point that it was a local municipality, local law enforcement, whatnot, that indeed did something, I'm not going to use the word I want to use, but did something that withheld something. They were at fault, so they would assume that liability. What the bill is doing at this point is basically saying, what's the state's obligation outside of the county, outside of the municipality? They're not covered at this point under the State Tort Claims Act. So this would be a bill that addresses just the state's responsibility. In a situation like I just explained, the individual could be compensated by the state and then go after the county if indeed there was liability on the county or city's part in a separate.
The reason I see this differently is we're talking about political subdivisions of the state. You know, we as a state very often we preempt local action because, you know, the state brought the cities and counties into existence. We've got the ability, other than things that specifically provided them in the Constitution and reserved their powers, we have many things that the state has really exclusive authority over. In their circumstance, there's local actors, there's arresting agencies, there's state law enforcement working with local law enforcement, there's a jail that holds people, there's that whole process is a mix of state and local players. The dollars we're talking about here to make people whole is a state action to say we're doing our best, aside from losing some years of people's life that they can never get back. We're taking an action to say we're making you whole. I believe when that happens, and the state takes this action, we're taking this action across the state and all of its political subdivisions. And the idea that when the state pays this out, it's a very strong case that's been made. There's a big, as it were, there's a big pot of gold at the end of this. There's a big payout that's involved, and when that happens, you've established very resoundingly. You've paid attorney's fees. You've created all this to establish that. If that can then be taken, all the effort to go get this claim can be brought to bear against locals that might have been involved in this. In every case, will have been involved to some degree. I think this effort, as I think through this, we as a state are acting across the board for the state and its political subdivisions, and this waiver ought to apply to all. And that's to members of the committee. That's the nature of my amendment. If it applies vicariously to officials, then I could simplify the amendment.
Let me recognize Chairman Atwood.
You just for the committee's thought, you could have, I can see, two separate actions. You could have an action whereby a person, and this is meant to help, I think, those that are found to be innocent, and apart and above from that, if you had another cause of action, let's say a person was shot not appropriately, they were shot, they were not armed, whatever, or they were in a car wreck, or they were run off the road, or something else, there could be a separate and distinct action that they may want to pursue that's part and above from their innocence and being incarcerated separately. That's the concern with the amendment.
Representative Gravely.
To Chairman Settler's point, and you'd have to correct me, Ms. Travis, by Constitution, the county is a political subdivision of the state. Does the state's immunity extend 100% to the county? My understanding is that it's a decreased level of immunity, or it's proportion. But the city is not political subdivision. It's created by the state. So there would, what we would be doing is providing immunity to the county and the city in this instance where immunity is not provided to the county and the cities and in other instances of liability issues.
Cities and counties are both political subdivisions of the state. Their immunity is, as I understand, I don't want to outkick my coverage. Their immunity is a little bit different, as I understand. Ms. Travis, is that not true?
Okay. I think everybody understands the issue, and so let's consider the amendment, which I think the way you worded it, Chairman Sessler, would cover what your concern is, and I think we should call for a vote.
One last thing, Mr. Chairman. So I'll restate the amendment in direction of Atwood's question. I'm not seeking to prohibit any civil remedy against an individual. That certainly ought to be available, but I think when we act as a state, it ought to apply to a political subdivisions who are involved. So the amendment, Mr. Chairman, would read, this committee, adding on line 173 against the state, insert or any political subdivision of the state. Period.
Okay. Did you get that, Ms. Travis?
I did.
Okay. Those in favor of the Setzler amendment in line 173 indicate by saying aye. Those who oppose? No. The noes have it. The amendment fails. Any other amendments? Okay, I think the procedural posture is that there's a motion to do pass, and as amended by the House, motion to do pass, House substitute to 230, as amended by this committee. Okay. Those who are in favor of recommending due pass recommendation to LC 296553S, House substitute to HB 230 as amended by this committee, indicate by saying aye. Aye. Those opposed? No. Okay. Ayes have it. It passes. Thank you. All right. Chairman Stevens, House Bill 513. Chairman Stevens.
Thank you,
for your
Mr. Chairman.
patience.
Yes, sir. The House Bill 513 was brought to me by the film industry of the U.S., not our state, but the U.S., where we're having a growing industry in frivolous lawsuits. Typically what happens here is towards the industry, somebody will come up with a lawsuit knowing that it's going to cost, I don't know, $50,000, $100,000 to settle, and that's exactly what they will do. Is it's out of the frivolous nature, it becomes a business. What 513 seeks to address, of course, number one, protects the rights of Georgians to speak out on issues of public interest. It does deter the abuse of the judicial system and unmeritorious lawsuits targeting the exercise of their First Amendment rights. If the court determines a lawsuit is without merit, the plaintiff will be ordered to pay the attorney's fees incurred by the defendant. And of course that works both ways depending on the joint judgment. Expensive discovery is suspended until the court rules on the motion to dismiss or motion to strike. It does not apply to lawsuits brought by attorney generals, district attorneys, or city attorneys. The legislation is very important to the expansion of the motion picture and TV industry in Georgia. It tracks very similar language, anti-slap language legislation that was created in California over 20 years ago, and is widely credited for reducing the unmeritorious lawsuits targeted free speech. Responds to the 11th Circuit case decided July the 10th of 2014, negating the verification requirements in the federal case, result in let's see. Just if I may, Mr. Chairman, let me go down some of the film industry stuff that, just to refresh some of your memory, if I may. The meritless lawsuits are targeted at protecting the First Amendment rights of free speech. And unfortunately, a byproduct of the growing film industry, the production of the industry in Georgia. Film has grown from a $200 million business in the state to an economic impact of over $5 billion last year. Last year in 2014, Georgia created more films lensed in Georgia than the state of California. That was a first. Film production is significant to the state's economy. In 2013 alone, 23 movies and 39 TV series were filmed in Georgia, including The Anchorman, Dumb and Dumber 2, Hunger Games, Mockingjay Parts 1 and 2, $1 Million Arm, Need for Speed, SpongeBob SquarePants 2, filmed in Savannah, Transformers, Age of Extinction, TV series, which includes The Vampire Diaries, The Walking Dead, which is the #1 cable series on cable today. And in 2013, $934 million in direct spending in the film industry resulted in $3.3 billion in total economic impact and 30,000 jobs. Best Picture nominated Selma was shot in Georgia and generated $10 million in a positive economic impact alone. In recent years, to get to the crux of the problem, Williams versus MTV Networks complaint alleged that, among other things, defamation, misappropriations, and false light and interference with a contract involved an episode with MTV series. Fulton County Superior Court was filed in February 2011 and resolved July of 14. And the list goes on and on. So what we're asking for here is that we on 513 is that we prevent these frivolous lawsuits, at least slow them down by making the plaintiff as responsible for, when judged to be a frivolous lawsuit, to pay attorney's fees and court costs. And there's a lot of people here to speak, Mr. Chairman.
Questions for the author, Representative Strickland.
Thank you, Mr. Chairman, and to the Chairman of Economic Development Tourism Committee. I like the bill. I like the concept, big supportive film industry. I have a couple procedural questions. It might be more for Legislative Council. But on line 33, we cite Code Section 91135. Is that supposed to be citing 91156, or?
That's what I thought too.
Okay. I think we may just have a error as far as the code section that was cited on line 33. But the other question I had, and I don't know, Ms. Travis, is this something you can help me with as well, but if the court is determining whether or not someone will prevail on summary judgment, is there an opportunity to get notice that you have to now submit affidavits when you, I mean, wait, we're reading this right now. Someone has to file a motion to strike, and you have 10 days to try to cure and provide the verification you have to provide with existing law. But if someone files a motion to strike now, is there any sort of procedure that would fall into place that would allow someone to cure not complying with this code section and be able to actually go and file the affidavits required under 91156?
Actually, I think it's done in reverse on line 86. An order granting or denying a motion to dismiss, a motion to strike shall be immediately appealable.
Okay. And I think it just goes more to the logistics of the procedure, because 91156 has a set procedure as far as the summary judgment. I mean, I think someone can interpret this and just say, well, they've got to file an affidavit and show me they might could win on summary judgment. They could just look at the petition. I was just concerned about the logistics of how it would be interpreted.
Point taken.
Representative Trammell.
Thank you. And just a question. I mean, I think what I hear you saying is the intention is to make these suits more difficult.
Yes, if they're frivolous in nature.
And, Mr. Chairman, just an observation. It may be subject for the debate, but using the summary judgment standard and removing the written verification and the requirement that the attorney seems to make it simpler rather than more difficult to bring these claims. Just for what it's worth.
Okay. Any other questions for Chairman Stevens? Representative Coomer.
Thank you, Mr. Chairman. can you help me understand what we're talking about when we say any act which could reasonably be construed as an act in furtherance of a person's right of petition or free speech? What kind of acts are we talking about? I don't really understand that language. Is that that phrase a term of art that lawyers practicing in this constitutional field would understand? Because I'm not one of those, and I don't know.
Me either. Good.
Counsel?
Yeah.
Is there a lawyer in the house?
Holly Manheimer with the First Amendment Foundation, and I'm not here on behalf of the film, on behalf of citizens. We are supporting whistleblowers use this statute, and it's folks like I had a case early in 2000. She complained about the Humane Society, and she wanted to get heard on this in front of the county commission. So things like that, when we're trying to complain, whether it's to an official governmental body. And what I like about this is you don't have to go in front of the county commissioner. As long as you're speaking out on a matter of public concern, that's the kind of thing. But yes, it's a term of art.
Okay, maybe you can help me understand how that then helps the film industry.
That I'll leave to the experts on film. I would say that, you know, the statute's not that old. It came into law in Georgia, I think in 2001. There were a handful of cases brought by whistleblowers who, you know, complained of a variety of things and combated defamation issues, things like that. What I like about this bill, and I'm sorry if I'm out of order, I don't know, some of the things that didn't work earlier in the decade, like discovery, we always used to have to fight. Discovery wouldn't stop. So this seems to try to strengthen that. Also, the attorney fees things, yeah, if you win on this kind of thing, defense counsel is putting an awful lot of time and energy. So from my perspective as a citizen's bill, this does strengthen things. I can't speak to the film industry stuff, but I'll let the experts speak
Thank
to that.
you.
Thank you.
And there are some.
Talk about logistics on these anti-SLAPP statutes. When you file a motion to strike, it's not one of the 12B motions that tolls discovery. Because discovery, is, you know, under state law, is about 90 days to state when the court rules. In federal law, it's automatically stayed until 12B motions are. So it would seem to me, and I kind of thinking about it, I agree with Mr. Trammell that in a summary judgment motion, filing an affidavit with no benefit of discovery, I don't think it's very hard to craft your affidavit so that when the judge looks at the affidavit in the light most favorable to the non-movement, to defeat any motion to strike in that regard, unless it's a clear area of the law, right? For example, they litigated this and they lost in another jurisdiction. That's, you know, they're precluded by, you know, claim preclusion or res judicata, whatever. But I'm not. Maybe we could hear from the advocates of the bill. I'm not quite seeing the benefit of that because I could see right now it's going to be very easy to defeat this motion for strike. Especially if it's a factual issue. If you don't have a legal issue, I'm not sure if it makes it, if it achieves the goal that you were trying to achieve in this regard. So, and nobody else kind of signed up for this bill, but I know many people support it. Mr. Edge?
Mr. Chairman, we support the bill. We'll be glad to address that at
Sure.
time.
Sure. You didn't get a chance on it. I think any other questions for the author right now? And I didn't see any questions, so that will be the time. Oh, I'm sorry. Mr. Grabber.
How are we making the determination upon, to determine whether or not a lawsuit is frivolous?
That's
So
also can be handled with the
okay,
attorneys.
okay. I'll reserve.
Okay. Thank you.
Mr. Edge?
Mr. Chairman, members of the committee, I appreciate the opportunity to come before you. Skin Edge, we represent Time Warner and Turner Broadcasting. To try to address some of those questions you mentioned, first of all, in terms of whether or not, how do you determine whether or not it's frivolous? I think it's whether or not it has any legal basis under the law is really the definition for whether or not it's frivolous or not. In terms of the affidavit, Mr. Chairman, members of the committee, I think if there is a factual dispute, a legitimate factual dispute, just like a motion for summary judgment, then the court's going to defer to a jury on that type of thing. I think what this is designed to try to do is get at whether or not, even with an affidavit filed, even viewing it in the light most favorable to the non-moving party, that is, a respondent to the motion to strike, is there any basis at all for this type of action? And if not, this allows the court to go ahead, dismiss the action before the expenses of litigation, discovery, those types of things, not to mention inconvenience to the witnesses who have to be deposed, answer interrogatories, and so forth. They avoid all of that if it's very obvious from the outset this is really more of an harassment type of lawsuit, a shakedown type of lawsuit, and has no basis whatsoever. That's really what we're trying to get to. If it's got some merit, if it's some factual disputes, not only we're not going to get past this motion to strike, we're not going to get past the motion for summary judgment. That's for a jury.
Any questions for Mr. Edge? Isn't there already a statute that governs frivolous litigation?
There is, and we are amending part of the statute here. You'll see, but the concern we've had and the reason this bill is being brought forward, there have been some case law indicating that, as was just alluded to a moment ago, that only applies to actions taken by legislative, executive, city councils, that type of thing, governmental agencies or bodies, as opposed to perhaps private parties who are being sued. You know, might have a situation where a film or TV studio is doing a documentary or a film about a person, and they write them a letter saying, if you proceed with this, we're going to sue you. And in fact, they do go ahead and sue when it turns out they're a public figure. They have no basis for the lawsuit whatsoever, and that's the kind of thing we're trying to avoid, so that we don't have to spend time and money on that.
Representative Trammell.
Yes, thank you. I'd just throw out a query as to whether or not a procedure that might accomplish what the intent of the bill is, to have some type of hearing the way we do in some of the extraordinary writs, which require a quicker time to trial, which would alleviate this. The problem I have is that using the summary judgment standard, a plaintiff with impure motives, or plaintiffs do this all the time, they draft an affidavit in a way to survive this initial test, and we're right back where we started. I mean, maybe they get assessed fees, but we've gone through this process where we can't get them over that standard of viewing their affidavit in the light most favorable to the non-moving party.
Right.
And I think that if we could compress that the way that we have, for example, in the declaratory judgment context, where you have to have a trial or a hearing within a set number of days, that we probably get where we're trying to get with this in a way that is more sustainable than motion practice that is subject to the summary judgment standard.
Representative, I hear what you're saying, and I can see your point. Of course, we're basing this on a law that has been used effectively in California, and that's the reason we brought it this way. And again, we certainly want to err on the side of caution. If someone has a valid claim, then it should be able to go forward. But in situations where it's just patently obvious that they don't, then we want to be able to dispose of that as quickly and expeditiously as we can. And this is a proven method to do that.
Okay. Logistically, I'm looking at it. I'm looking at 9/11/12, which stays discovery for 90 days. And as I read it, and I could be wrong here, only motions to dismiss holds the discovery for 90 days. So if it's motion to strike, you can imagine if you file it in Fulton County Superior Court, you might not get a ruling until 6 months later, which means you would have to proceed to discovery, which defeats the purpose of what I think the author of the bill is trying to accomplish. So in effect, what you need is, and I'm just shooting at the hip right now, what you need is a mandate that the court resolve these things at a certain time, like a motion to dismiss and whatnot, before ordering discovery, so you could get your savings, right?
Right.
Other than if not, because basically what you're doing is you're asking for them to convert the pleadings and the affidavits into summary judgment, which the courts could do. But I think motion to strike might be the wrong vehicle to do it. Just my 2 cents of kind of how the bill might work. And I do agree with you.
Or perhaps an amendment dealing with the discovery issue to this, saying that the discovery is. is told or while the court rules. Might be a way to handle it,
Okay.
Mr. Chairman.
Mr. Coomer.
BJ, I'm sorry, Representative Pack, doesn't that issue get, isn't that subsumed in lines 80 and 81, the language already existing in statute?
Nope.
That, and on down through that paragraph.
Okay.
And it looks like even lines 82 and 83 deal with the placing a time limit on the court.
Which my understanding is they're not really abiding by.
Well, so long as the discovery stayed, I think that accomplishes that, and that's a good catch. Yes, sir.
So there's a current statute in your amending, right? Okay.
Yes, sir.
Representative Trammell.
I'll just offer the benefit of some experience with strategic purpose litigation or something that touches on this. A lot of times the aim for the plaintiff is just to halt or slow things down. I just go back to that point about that hearing and having a due process opportunity for a dispositive decision. I mean, it works to frustrate what a lot of plaintiffs who are up to no good, they're not worried about the fee shifting. They're just trying to buy some time. I'll just throw that out. That's my own thought on it.
Again, I understand where you're coming from, and I appreciate that. I would just say that we feel like that if they're looking at being hit with cost and attorney's fees, that's going to be a pretty strong deterrent.
Mr. Chairman, if I might, just can you help me understand from the industry's perspective, what exactly these lawsuits, I mean, other than being frivolous and an irritation,
Right.
how do they affect the business purpose, or what is the industry trying to avoid?
Well, it goes back to what Chairman Stevens was saying a moment ago. You've got a situation where a studio, for instance, or a TV station, in our respect, is moving forward on a project or a story. They are sued, and then they are told, if you'll pay me X number of dollars, then we'll go away. And they're faced with a situation saying, well, is this just a cost of doing business, or do I want to get this lawsuit dismissed as quickly as possible and move forward? And we've unfortunately seen this many times in the business where figures and individuals will do this, hoping that they simply can extract some money because they're hoping that the studio or whoever the business is will find it's easier and cheaper just to do that as opposed to deal with the lawsuit and the resulting litigation. Unfortunately, it's not uncommon. That's why California, which used to be the film capital, passed this statute years ago, and now Georgia's in that situation. We're having to deal with the same type of issues and problems and claims.
How different is the statute in California to language in 513?
It's virtually the same.
And what was it exactly that the 11th Circuit did?
I'm Tom Harrell. I represent the Motion Picture Association of America. And in July, the 11th Circuit threw out the verification standards in the Georgia existing statute. So what it's resulted in is some forum shopping. And with this,
the experience in California has been a tremendous deterrent to the frivolous lawsuit. So that's the main reason.
Okay, what do you mean by forum shopping? Whichever state, so you might...
No, district court or state court. Because if you go to federal court, you don't have to do the verification affidavits, and it's more expensive. It takes longer. But it has been a very effective deterrent. And we had a national meeting of all the studios in December, and the accolades of Georgia were terrific. And they just said this is the #1 issue for them in the state now. But everything else is great. They really were very complimentary of the state, Lee Thomas, the state film director, who's done a great job. So we just hope it is a deterrent, and that's the purpose of
it. Okay.
Thank you, Mr. Chairman.
Sure. Holly Manheimer, did you get a chance to speak before? Or
yeah, I don't have anything to add other than the benefit of having litigated under the statute in its earlier form. But it's supposed to work, the statute, the way all of you have asked. It's supposed to stay discovery, get in front of a judge early. Now, I'll say it hadn't worked that way so well. But I am for, and we are for this improvement. We think it strengthens the law. And again, you get, all you practice in the superior courts, a lot of judges you get in front of, they're not familiar with it. What's 9, 11, 11.1, and so, but the idea is supposed to get an early hearing. It is supposed to stay discovery and to get rid of lawsuits that are frivolous early. I'm hopeful that this will improve it and make it work better. But again, I was an early litigant in the area. Thank you.
Chairman Atwood.
Yeah, I just have a couple of questions. I'm a little concerned about this. I mean, hasn't current law worked pretty well for a couple of decades? I mean...
It only was passed, ironically, in '01. I think that's when so it's a fairly recent law, and we don't have that much litigation under it in Georgia. I'm trying to remember. My case was one of the first handful, but it's worked okay. It can be better. The problem in my lawsuit, as I referenced earlier, is I didn't have my speaker's comments weren't in front of an official body.
Yeah.
Wasn't in front of the. I thought it was in front of the Fulton County Commission, but not. But yes, it's worked well enough.
I think you may have misunderstood me. I'm thinking of I don't practice tort law. I don't do that. I defend businesses. I'm in business litigation all the time, and I'm certainly for our film industry. But I'm a little concerned that we're creating possibly a separate standard for a separate industry. I like to keep the doors open. I'm looking at a film industry against a little guy, and I'm a little concerned about that here, that maybe a different standard is somewhat being created. Just my thoughts. That's what I was talking about.
Yeah, and it's an interesting, the folks from the public interest arena, my predecessors at the First Amendment Foundation and other nonprofits ultimately pushed for the statute when it passed in '01 or whenever it was, in an effort to protect the smaller guy with the smaller speech. I was surprised a little bit when the film industry called me and said, "What do you know about it? Will you speak for it?" But I can't speak to the film industry. I can say that most of the cases have protected whistleblowers, and that was their intent. The statute has worked so far.
Thank you.
Thank you.
Do we have any current, it's for the film experts, Mr. Chairman, as well, do we have any current examples? And let me preface it by saying this. In 2004, there was no bigger advocate for the film industry in Governor Perdue's office than myself. Having set that initial redraft of the board up, having been threatened to be fired because of my advocacy for it, that was something that was my passion in Governor Perdue's administration. And I'm delighted to see where this industry has come. My counties benefit from it. I want to see it continue to grow. I would share Representative Atwood's concerns and would ask for some examples, maybe over the since maybe what are we at, $5 billion a year that the film industry brings into the state, and currently with the revenue numbers from the last 2 or 3 years. I think we've steadily been increasing. We were at $3 billion in 2012. In that time frame, how many suits like this have we seen brought forward and kind of what happened with those suits? Or were they thrown under the judge's discretion? Were they thrown out as frivolous, having no basis in law? Did some of them maybe move forward because of some evidence?
There's one case in DeKalb County down at the Georgia Supreme Court where the Superior Court judge denied the anti-SLAPP motion because the judge said it was not an issue, a public issue, and the public issue didn't cover it. It was not a governmental issue. And this involved the guy that claimed to have a Purple Heart, and he actually didn't. And so he sued, and that's at the, as I say, the Georgia Supreme Court. There have been, I think, about 7 or 8 suits filed against Universal, against Vicom. Vicom has been sued 3 times, I think. And a lot of them are settled after the lawsuits are initially filed because they just don't want to go through the expense. And it's more of a nuisance for the industry, and it's just something they said, well, could you fix it? I said, we'll try.
But I think it's important, if I could, Mr. Chairman, I think it's important to Representative Atwood's point a moment ago. This bill is not limited just to the film business or the TV business. I mean, this will apply to anyone. I mean, theoretically, if I read this way I'm reading this, if one of you in a public forum making comments in a speech and somebody wanted to sue you, saying you had made some false statement about an issue of public concern, this will allow you to have that suit dismissed. So it's not limited. This is not a special interest bill just for the film industry, TV. It applies across the board.
Question for the author. I noticed that with court in awarding attorney's fees under 55 to 59, right, so they look at sufficient probability that the non-movement will prevail, okay? And it says, if, for example, the defendant who sued prevails in a motion to strike, they're entitled to recover his or her attorney's fees and costs. Then I look at lines 63 to 64, the burden is completely different. So if a plaintiff, in order for the plaintiff to get attorney's fees, he or she has to show that the motion for strike that was filed by the defendant has to be frivolous or solely intended to cause unnecessary delay. It seems to me kind of a little bit lopsided in terms of burden. What if it's something like automatically, if you lose your motion, the other side gets the fees, versus, you know, having it only frivolous or intended to cause unnecessary delay? Yeah. Representative Atwood.
Mr. Chairman, just at the proper time, I'd like to make a motion to table. This thing needs to move slowly, and I'm concerned about it. I'm concerned about a vote today.
Okay. And we do have 5 minutes. I think this is a very important issue, and I do want to address kind of our growing industry and want to make sure we discourage frivolous lawsuit. But we're on day 28, 5 minutes till 5 o'clock. I think it might be wise to take a step back and make sure that we're doing what we're doing. It seems to me, especially in light of the evidence, that it doesn't seem like the current statute is not that broken currently. But Chairman Atwood, I would recognize you for a motion at that time.
At this time, motion to table House Bill 513. Study it a little bit more.
Motion to table House Bill 513. Do I hear a second?
Second.
Second. Those in favor of tabling House Bill 513 indicate by saying aye.
Aye.
Those opposed? Okay. Table it for right now. Thank you, Mr. Chairman. And we're adjourned.